Is your union a threat to America's national security, or is the government using national security as a smokescreen to take away your rights? I'm an attorney who represents federal employees, and last week something unprecedented happened. The Trump administration filed a lawsuit in a carefully selected Texas court seeking permission to terminate union contracts for hundreds of thousands of federal workers, claiming that these unions threaten, quote, national security, end quote. In this case, they went on the offensive, likely to tailor, I think, the case to a specific single federal judge who they thought would favor their argument. So here's exactly what's happening. Under a specific federal law, 5 U.S.C. 7103B, and a related law, the president can exclude agencies from union negotiations, but only if two strict conditions are met. First, the agency's primary function must be national security, intelligence, or investigative work. Think CIA or FBI. Expect unions to argue this list targeted what was intended by the statute. Second, and critically, the administration must show that collective bargaining agreements, or CBAs, cannot be implemented, quote, in a manner consistent with national security requirements and considerations. Here's why that matters. It's not enough just to argue unions make management decisions slower or less convenient. The administration has to prove, I would argue, concretely, that collective bargaining makes it impossible, or at least practically impossible, to achieve national security goals. For example, the administration says union agreements create delays because they require performance improvement plans before firing underperforming employees, or involve lengthy midterm negotiations. This is the same administration that falsely fired many probationary employees. Now, I think many courts typically should not accept generalized complaints like this. They would want something more specific, showing how these procedures tangibly endanger national security or investigative missions. Now, they might not require a huge showing, but there should be at least some. Also, courts are usually deferential to presidents on national security issues, but in this case, there's a specific statute requiring the administration to show, quote, again, that the collective bargaining agreements cannot be implemented, quote, in a manner consistent with national security requirements and consideration. So Congress has weighed in here too. And here's something else we should notice. The administration filed this lawsuit specifically in Waco, Texas, with a single judge they likely see as favorable. Right, there's one judge there, so they picked that judge. If the administration's legal argument was clearly strong enough, why target just one judge? So here's the real question. Is this lawsuit genuinely about national security, or is it about weakening unions and cutting federal employees' rights? Given recent national security breaches and urgent threats facing the nation right now, shouldn't the administration be focused on those things as threats to national security instead of spending resources targeting your union rights? Ultimately, the courts will decide whether national security is truly at stake, consistent with the statute, or if this is just another political move. But it's up to all of us to stay informed and hold our government accountable, including by following along what is happening. If you're a federal employee or just someone who cares about your rights, tap the first link in my bio to get on a newsletter. Let's stay ahead of this. Thank you, everybody, for your time, and I hope you have a good day.